This is number 5 of the alimony series. This time we're going to enhance our understanding from the last presentation, number 4, where we went into the primer on alimony law in Florida, and now look at it a little more focused on the types of alimony in Florida that are available to spouses and the payment of alimony, etc. All right. There are 4 types of alimony outlined in the Florida statutes, and they're classified, 4 types or classifications of alimony. Please note that you don't see the word on this list of lump sum alimony. That's important, and I'm going to discuss it as I move through this lecture. There's bridge the gap alimony. It's a transitional type of alimony designed to take a person from married to single life. They're short-term, one-time expenses for a new household, and listed here are some of the areas that might account for the need for bridge the gap alimony. Rehabilitative alimony, this is what the name says. Due to being out of the workforce, a party may need support for a limited period of time to find employment. Maybe you have a nurse with a license that's become outdated during marriage and needs to be updated through schooling or additional certification, etc. Or skills need upgrading. The spouse who doesn't have a job that is well-paying because there is a lack of skills. So it is just exactly what the name says, rehabilitative. Durational. Durational is similar to bridge the gap alimony because this is a new type of alimony, actually, durational. This came about because a different type of alimony was needed to overcome the large need for permanent periodic alimony, which I'll discuss next. Permanent periodic alimony is something that it was formerly the norm, but durational came into play a few years ago in Florida. I think it was 2008, because there were short or moderate term marriages. Remember from the previous presentation that the court does look to the length of the marriage to decide whether how much alimony how to calculate alimony, how to determine alimony. And so they came up with this durational because people weren't fitting into the permanent periodic alimony, but there was a need and an ability to pay happening a lot. And so it's similar to bridge the gap because it's going to help a person from the status of married to single, and it may be that it's suitable for a short or moderate term marriage. But the length of the alimony, if there are periodic payments, for example, cannot exceed the length of the marriage. So if the marriage was 7 years, it can only be 7 years of alimony. If the marriage was 14 years, only 14 years of alimony. And that's durational alimony. Permanent periodic alimony was formerly the norm. It's not very often granted today, and it's based on marriages of extremely long duration. And a spouse who is unable, due to age, retirement, disability, or something that happens usually later in life, after a long marriage, the person has no marketable skills, cannot work, and not enough time to acquire them. You can't send a 70-year-old person back to school and expect them to acquire that education and put it to meaningful use in the period of time necessary. Their life is rather short-term at this point, at that age. Maybe the person has some illness, disability, or something, or mental infirmity, and has reached past, like I said earlier, past retirement age. What you should be seeing here is that if a lawyer is looking at a case, they're going to look at the specific facts of the marriage, such as the length of the marriage and the type of need that the person who is proposing the receipt of alimony, what type of need that person has. And one of the things that Lupino mentions in the book is alimony isn't really favored by judges or the legislature, but one of those reasons is because there needs to be a clean split between the parties. And so the idea needs to go to that classification. Choosing a classification of alimony needs to look at that as a foundation to it. So there can be a clean split. And so these different types of alimony will apply to different people. And sometimes a client will come in that needs permanent periodic alimony for a variety of reasons like those listed here. But if they don't qualify for that, then look to durational and recognize that it is only as long as the term of the marriage was. Rehabilitative, if there's a need for updating skills. Bridge the gap is very short term, and it's to move the person from married to single life, and has some pretty specific facts backing it up. Alright, so a little longer one. Now we look at each one of them in a little bit more detail, because remember in the previous presentation I said that an attorney, and for both sides, the attorney is going to be looking at the four primary core, not legal concepts, but yeah, they're legal concepts. The primary concepts of alimony: purpose, duration of the marriage, modification, and termination. That's why for each of these types of alimony, I have taken it and made this little table out of it so that you can look at how the legislature has also written the statutes to define those four categories that are important. Bridge the gap alimony is to support the transition from married to single life. The duration of the marriage is not considered in this type of marriage, where this type of alimony is concerned. It can be any length of time. It's based on what do we need, what is needed, and for what purposes is the money needed, the alimony needed. And so any length of marriage. This type of alimony, however, can't be modified. It will terminate on a specific date, and it cannot exceed 2 years. So a long marriage where permanent periodic alimony might be possible wouldn't go into the bridge the gap alimony category. It terminates on the death of either party or the remarriage of the recipient spouse. So if a spouse is getting bridge the gap alimony and they're supposed to get something for 2 years and dies after 1, that payer of the alimony does not have to pay any more alimony. Rehabilitative alimony. Here is the purpose, duration, modification, and termination. The purpose of rehabilitative alimony is to establish a capacity for self-support. There is no specific directive in the statute that provides that this is only for marriages of a certain length. So it's not there. There isn't any measurement stick there. If a person, however, doesn't take actions that were established as the purpose of the alimony, such as going to school, updating career needs like the licensure of the nurse that I talked about in the previous slide, a modification of it is possible. And if they don't, you can lead a horse to water, but you can't always make the horse drink. If the horse doesn't drink, the horse loses alimony. And termination of alimony is also possible, realizing that many times in most types of alimony it terminates on death. Sometimes there might be a need to terminate the rehabilitative alimony. Maybe the rehabilitative alimony was based on an illness and the person thought they were going to get well and go to school, and finds out later there was a complication in the illness and there's no way the person can go to school. So let's not pay for school, let's modify it, or terminate it I should say, because the person's going to now get benefits from the government, that type of thing. In other words, the person's need still isn't in existence, or still is in existence despite the change of circumstances. And that's a substantial change in circumstances, which is the legal test as to whether it can be modified, rehabilitative alimony can be modified or terminated. All right? Durational alimony, that's the third classification of alimony. It's pretty popular. The reason it's popular is because so many people don't fit into those really long-term marriages that tend to go with permanent periodic alimony. And it is for economic assistance for a set period of time instead of permanent period of time. And it can be modified or terminated if there's a change of circumstances or if one of the parties dies. The length of the award is usually not modifiable unless it's something very exceptional comes up. And under no circumstances does the length of the award last longer than the length of the marriage. It terminates upon the death of either party or upon the remarriage of the recipient party receiving the alimony, or based on substantial change in circumstances. All right, permanent periodic alimony. Realize that the term periodic, it just means that it's paid on a periodic basis. It may be monthly. It may be annually. It may be biannually. It may be bi-monthly. The only point of periodic alimony is the word periodic and permanent periodic alimony is that there's a set amount and that it's periodically paid. It looks more than any other to how the marriage was benefiting the receiver before the divorce. If a couple had a substantially high dollar life, the court has to see the right kind of evidence other than circumstantial to show the need. They'll look for financial information and want to be shown that there was a substantial lifestyle that the couple had. Modification is possible, again, on to substantial change in circumstances or the existence of a supportive relationship. We'll talk a little bit more about supportive relationship, but just recognize that, if a person receiving permanent periodic alimony gets into a supportive relationship, moves in with a friend, even if they don't get married, maybe a friend moves in with that person, that permanent periodic alimony can be modified. And termination happens on the death of either party or upon their remarriage of the party receiving the alimony. Alright, so those are the types of alimony. Those 4 classifications are the types of alimony that occur in a marriage, and that would be what a judge at the end of the dissolution of marriage would determine based on his or her discretion and the facts. However, there are situations before the divorce ends, before the judge gives an order, where a person needs to have some temporary alimony. And many people, like the author of the Lupino Miller textbook and possibly Keene, I can't remember, use the term pendente lite. And it just means pending litigation. That's why it's temporary, because the litigation will end. Even if the case is dismissed because they decide to kiss and make up, the case will end. There will be dissolution of marriage, or one of the parties will die and there will be no need for dissolution, etc. So it's pending litigation, and it's something that happens a lot. Again, the same legal criteria come up. Is there a need for it, for alimony, and is there an ability to pay the alimony? In English, like I said, it's just an outcome of divorce litigation, and the same criteria where that applies to these decisions. And also listed on this slide, recognize that alimony pendente lite is even allowed in annulment actions, but it's not refundable even if the marriage is found void. And decision often based on abbreviated proceeding. This is just something that happens in a quick proceeding in Florida, I think they even have to have mediation before they can before they can file an alimony pendente lite motion. And that can be really hard because sometimes the person who needs it so badly doesn't have the money for it, for the lawyer fees. It's a problem. It's a problem in some districts. They require that, and I've talked to people who say that's a problem. Waiver. Sometimes alimony is waived. Sometimes they have comparable income. They waive it. They don't ask the judge for alimony. Everything's fine. We don't need it. And so it ends the question for final awards. There can't be a modification. Also, sometimes it's not clear under the present circumstances if alimony is going to be needed. And remember that the judge makes a decision and it's only modifiable if it's modifiable according to the category of alimony, durational, permanent, bridge the gap, or rehabilitative. Only if that type of alimony will provide for it. In some situations, it's not clear what the future is. And then remember, the judge makes a decision based on the present time. And it's possible, although rare, to get a nominal award of alimony, such as $1. And because of that $1 award, the court still has jurisdiction to modify alimony if the substantial change of circumstances comes about, and if the type of alimony that this $1 is awarded, the category of alimony that this $1 represents, is one of those that's modifiable. All right? So the point here is that the court can award nominal amount in order to keep the alimony in the jurisdiction of the court so that it can later be modified if such alimony is modifiable. Here we look at the Blanchard versus Blanchard case. This is another Florida case. This is out of the 2nd District Court of Appeals. In fact, that's in the same district where our college is, in Manatee and Sarasota and DeSoto County. They're all in the 2nd District Court of Appeals. And in this case, it's an example of a career change situation that has some interesting outcome to it, because it kind of looks at you can see a problem from both sides here. Now, the husband made a risky career change, and the wife wanted alimony from the husband, and she said that he had the ability to pay, or would have the ability to pay, had he been in his previous line of work. But he took this risky situation, and so, he would have the ability to pay if he didn't do that. Now, the wife was actually ordered to give him bridge the gap alimony. And she was foreclosed from modifying the court's decision denying her alimony. And this could have been avoided had she been given the nominal alimony that I've talked about earlier, like $1, so that if that risky business venture got better, and he was in an ability to pay category, or in the framework of having the ability to pay, and she still had the need as of the time of the divorce, then she could have sought a modification. But it wasn't available to her. If there's no award, it can be appealed, but it cannot be modified. So that's kind of one of those important topics, and a good case to read to fulfill your needs to learn more. All right, so how is alimony paid? I'm sorry. Types of alimony reimbursement. Now, there are some things that we hear about from other states, and we ask ourselves, well, shouldn't that person be entitled to alimony? And in Florida, one might argue that when one spouse goes to professional school, I decide to go to medical school or law school, or gets some specialized training, or takes on the tortures of grad school, and the other spouse, because of that, has to take on all the family matters, take on all the money earning, etc., and that kind of thing. So the person has expended a lot of his or her own energy and money taking care of the whole family while this other person gets this advanced degree and is going to go out there and make oodles of money as a doctor or a lawyer or something. Definitely not as a not with a graduate degree. That's pretty rare. And anyway, they're getting a divorce before that advancement takes place. In some states, the supporting spouse, that spouse who gave up all the money and time to help that person through it, might be able to get a form of alimony for that. But listen, this isn't true in Florida at all. In fact, even we go to the next chapter of distributing property, an educational degree is not even considered property that can be divided up, as in giving you some of my income because of that. So that's a tough battle in Florida. You can't do it. So the need and ability to pay may be influenced by an educational degree, but that's not the end of the analysis as far as it's concerned, because the court looks to the present. Now, this could be a situation where there's a need for nominal alimony, and if you can win it, then you have an opportunity to modify it later. But, that'll depend on other factors, like the length of a marriage and blah, 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 the type of alimony needed, etc., etc. Payment of alimony. This is important. Payment of alimony, we use this term, lump sum alimony. And as Keene, in his book on the chapter on alimony, notes, it's a legal fiction. It is not really alimony. There may be alimony in a single installment, or payments are different. Just that if it's lump sum alimony, it's not alimony. It's not true alimony. It is lump sum property settlement. It's about property distribution, not about alimony. So other payment types, even a lump sum alimony, can be made in one big single payment, or it can be made in installments. They're different from periodic alimony in terms of how bankruptcy laws and taxes are treated because of lump sum alimony, and we're going to go into that in a different chapter altogether, because the tax stuff it's just easier to handle all at once in one big lump. It's used for situations where you can't expect periodic alimony from this person who should be paying alimony, and it's a property settlement. It doesn't terminate on death because it's property settlement. In all actuality, it's a property settlement. It can't be modified either because it's a property settlement. It's not alimony. Please read on 84 and 85 what Gerald Keene says in his divorce handbook about lump sum alimony. Other types of payment, it also could be a combination of different types of alimony. Cases can be complex, and even in Florida, the judge can order more than one type of alimony, bridge the gap and durational, bridge the gap and rehabilitative. The only exception is that durational and permanent periodic alimony cannot both be awarded. The durational is only appropriate if permanent is not. So the test is first, is this person eligible because of the factual circumstances for permanent periodic alimony? If the answer is no, you got to look to one of the other three categories: bridge the gap, durational, or rehabilitative. So the exception is that durational and permanent cannot both be awarded. But you start with, is the person eligible for permanent? If not, move on to the other types. Now, alimony doesn't have to be, it's not always simple. There are complicated cases out there, and there are reasons for it that are based on the facts that the parties are facing at the time of the divorce. It may be that the payments escalate over time. It may be that there's a cost of living increase each year or every 3 years. But it'll depend on the type of alimony and what the Florida statutes say about whether it's modifiable. And then again, the test for modifiability of those types of alimony that are modifiable would be substantial change of circumstances and things like repartnering with someone. Healthcare coverage, the COBRA was what we call it, the Consolidated Omnibus Budget Reconciliation Act. It provides that continuing health care for an ex-spouse under a covered spouse's policy can be considered alimony. However, so that means that spouse with health coverage has to keep the other person covered. And that doesn't necessarily mean that they have to pay the coverage. The person receiving the benefit may be the spouse that pays the monthly premiums. But the point here is that the covered spouse can get included on non-covered spouses. The covered spouse does have the ability to include the non-covered spouse on his or her policy following the divorce, and the court can order this. And the important thing too is there's a 3-year limit for the period of time that this can be done. And that's the law. That's what the law says. So the law says that it can be done, and the law says that there's a limit to how long you can do that. Life insurance. Life insurance is sometimes needed to secure alimony and child support payments. When a person receives permanent alimony and has no clear opportunity to self-support, then life insurance could secure that alimony. Now remember, it terminates on death. Permanent alimony would terminate on the death of either party. But let's say the payer, the person paying the alimony, dies, and there's there's no opportunity for self-support on the part of the person who is receiving it. That person was disabled, unable to work, whatever. Then life insurance can be ordered, because there would be nothing left if the only person that can pay is out of the picture. All right, this concludes this segment of the alimony, and we've covered some of the things about the types or categories of alimony in Florida, some basics about how it works. Do read the statutes and try to understand these, and recognize that when you're in the law office, pull up the statutes and look at them anytime. So you'll move on now to number 6.